Should the law allow doctors intentionally to kill their patients? When the euphemisms of doctor-assisted death and assisted dying are stripped away, this is the stark question at the heart of the euthanasia debate. The debate's not about whether doctors should be allowed to help people die. That's what good doctors do and have always done, by their skillful use of palliative medicine. It's what good nurses do and have always done, by their dedicated care of dying patients. The euthanasia debate is not about killing pain, it's about killing patients. It's always been against our law and against professional medical and nursing ethics intentionally to kill patients or intentionally to help patients kill themselves. And I contend that it should remain illegal and against professional ethics. I make the argument in some detail in this book, Debating Euthanasia, published by Hart Publishing in 2012, in which Professor Emily Jackson, who is a professor of law at the LSE, advances a case in favour of legalising euthanasia and assisted suicide, and I advance a case against. So you can read my argument in more detail there. In essence, my argument is, first, that decriminalising voluntary euthanasia or assisted suicide would be wrong in principle. It would breach a basic human right, the right to life, the right not to be intentionally killed. Second, the case for euthanasia on request, voluntary euthanasia, is also logically a case for euthanasia without request, that is non-voluntary euthanasia. Third, even if voluntary euthanasia and physician-assisted suicide were not wrong in principle in certain hard cases, as when requested by a competent suffering patient who's terminally ill, decriminalising euthanasia, even in that situation, would pose grave risks to the vulnerable, especially to the dying, the disabled and the disadvantaged. In particular, it would expose competent but vulnerable patients to pressure to request an earlier death, and it would expose incompetent patients to death without request. For the purpose of rebutting the current campaign for the legalisation of euthanasia and physician-assisted suicide, I contempt to adopt the definitions of euthanasia and assisted suicide used in the House of Lords Select Committee on Medical Ethics, chaired by Lord Walton, which was published in 1994. The Walton Committee defined physician-assisted suicide as the provision of help by a doctor to a competent patient who had formed a desire to end his or her life. And it defined euthanasia as a deliberate intervention undertaken with the express intention of ending a life to relieve intractable suffering. My focus is therefore actions rather than omissions which shorten life. This focus does not deny the possibility of intentional killing or assisting suicide by omission, but simply reflects the current debate. Campaigners for decriminalisation are pressing for doctors to be allowed to administer lethal injections, currently prohibited by the law of murder, and or to prescribe lethal drugs, currently prohibited by the law against assisting suicide. Let me just address some of the major arguments that campaigners for legalisation have pressed. At the forefront of their campaign is the argument from Autonomy. It's argued that decriminalisation is required out of respect for individual patient autonomy, to respect the right of self-determination. Patients have a right to make their own decisions about the time and manner of their death. Whose life is it anyway? Well, there are a number of responses to this argument. Firstly, our understanding of autonomy and its limits. So the principle of respect for autonomy has in recent years become for many a core, if not dominant, principle of biomedical ethics, but it's not unproblematic. Its advocates often fail to agree on precisely what constitutes a truly autonomous choice, or to offer any convincing reason why respect for someone else's choice as such should be regarded as a moral principle, let alone a dominant moral principle. Our capacity for choice is undoubtedly important, for it's through our choices that we shape our lives and influence the lives of those around us, for good or for ill. The advice, "Be careful what you wish for, because you might get it," is not bereft of wisdom. As Professor Luke Gormally and I have written, Autonomy itself as a capacity is to be valued precisely insofar as its exercise makes for the well-being and flourishing of the human beings who possess it. But it's plain that many exercises of this capacity, that is, many self-determining choices, are destructive of human well-being, both in the life of the chooser and in the lives of others affected by his or her choices. The mere fact that someone has chosen to act or to be treated in a certain way establishes no title to moral respect for what's been chosen. The character of the choice must satisfy certain criteria in order to warrant our respect. And the most basic criterion is that a choice should be consistent with respect for the fundamental dignity both of the chooser and of others. Neither Anglo-American law nor professional medical ethics has ever held that the mere fact that I have chosen justifies what I have chosen. English law refuses to respect various choices, however autonomous. It disallows choices to be owned, to be eaten, to be executed, to buy illicit drugs, or to drive while not wearing a seatbelt. In the medical context, patients have no right to demand whatever treatments or drugs they may want. So the focus of our moral inquiry should not be on some question-begging right to choose, but on what it is right to choose, on which choices merit or do not merit respect. Choices which undermine human flourishing, undermine human dignity, such as choices to kill or to mutilate, whether oneself or another, simply lack moral justification. Further, given that our capacity for autonomy is so valuable, how can it be right deliberately to extinguish it by deliberately extinguishing its bearer? Must liberty not at least sometimes be limited in order to be possessed? And one limit is the cardinal ethical principle of the inviolability of human life, sometimes referred to as the sanctity of life, but as that has distracting religious overtones, we'll use the phrase inviolability of life here. This historic principle, which is foundational to Western criminal law and to professional ethics, can rest on solely philosophical rather than theological grounds. It holds that it's wrong intentionally to kill other people, at least if they are, like patients, not involved in unjust aggression. The principle is grounded in the recognition of the inherent dignity of each human being. The preamble to the Universal Declaration of Human Rights proclaims that the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. The preamble has it right. Each of us shares an inherent dignity and enjoys equal and inalienable rights in virtue of our common membership of the human family. Human life is, like friendship and knowledge, a self-evident good, and is, like them, a basic rather than instrumental good. It's a basic element of human well-being, not merely a vehicle for a life of sufficient quality or worth. We all share a fundamental equality in dignity, regardless of our abilities or our disabilities. Even if we find ourselves sometimes in undignified circumstances, we never lose our inherent human dignity. There is no one whose life is not worth living, no one who would be better off dead. There are no second-class patients. The lives of all patients are worthwhile, even if some patients lose sight of their worth. The principle of the inviolability of life has long been instantiated in English law. It's also informed important documents on human rights. For example, Article 2.1 of the European Convention provides that everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally. The inviolability principle was cited by Lord Walton's committee as a major reason for its rejection of the legalisation of euthanasia or physician-assisted suicide. having carefully evaluated those arguments, the Walton Committee concluded, "We do not believe that these arguments are sufficient reason to weaken society's prohibition on intentional killing. That prohibition is the cornerstone of law and of social relationships. It protects each one of us impartially, embodying the belief that all are equal." A second counter-argument to the argument from Autonomy is that decriminalisation would prejudice the vulnerable, both those who are autonomous and those who are not. Some vulnerable patients, such as the frail elderly, might be pressured into requesting euthanasia or physician-assisted suicide. The Walton Committee concluded, "We do not think it possible to set secure limits on voluntary euthanasia. It would be next to impossible to ensure that all acts of euthanasia were truly voluntary, and that any liberalisation of the law were not abused. These dangers are such that we believe that any decriminalisation would give rise to more and more grave problems than those it sought to address." The committee went on, "We are also concerned that vulnerable people, the elderly, lonely, sick or distressed, would feel pressure, whether real or imagined, to request early death. The message which society sends to vulnerable and disadvantaged people should not, however obliquely, encourage them to seek death, but should assure them of our care and support in life." These concerns have been echoed by the philosopher Honora O'Neill, who said that legalising assisting dying places a huge burden on the vulnerable, let alone on the vulnerable and depressed. "Legalising assisted dying amounts to adopting a principle of indifference," she writes, "towards a special and acute form of vulnerability, in order to allow a few independent folk to get others to kill them on demand. We are to be indifferent to the fact that many less independent people would come under pressure to request the same." And these concerns should not be lightly dismissed, particularly as discrimination against the elderly and disabled, even in wealthy nations such as the UK and the US, is a sad and harsh reality. People with disabilities have been at the forefront of resistance to the campaign for legalisation. Baroness Jane Campbell wrote that if a physician-assisted suicide bill were passed, none of us will be safe. She wrote, "A law decriminalising assisted suicide would undoubtedly place disabled people under pressure to end their lives early, to relieve the burden on relatives, carers, or the state." The concerns are not side issues that only affect disabled people, but the disabled group were canaries in the coal mine, as she put it, who can often see the dangers of potentially discriminatory legislation before others, as it impacts on us even before the deed is done. We are scared now. We will be terrified if assisted suicide becomes state-sanctioned. Their reasonable concerns are unlikely to be assuaged by comments from some leading right-to-die advocates. Baroness Mary Warnock, perhaps the most influential ethicist in British government circles, has stated, "If you're demented, you're wasting people's lives, your families' lives, and you're wasting the resources of the National Health Service." She forecast, "I think that's the way the future will go, putting it rather brutally. You'd be licensing people to put others down. Actually, I think why not? Because the real person has gone already, and all that's left is just the body of a person, and no one wants to be remembered in this condition." This distinction that advocates of euthanasia often make between human beings and persons is mistaken and should not be followed, because it ignores the key fact that what grounds our innate human dignity is our radical capacity for rationality, free will and moral agency, a capacity that we enjoy in virtue of our nature, even if at any particular moment, as for example when we're a small child, we are not able to develop and exhibit developed intellectual abilities. So it misses this key distinction between a radical capacity, which grounds our dignity, and having the current ability to demonstrate that capacity. We all share that radical capacity, therefore we all share a fundamental inherent dignity. The right to die would then surely in time become more of a duty to die, not least given the burgeoning costs of caring for a growing elderly and demented population. It's often said that the true test of a society is how well it treats its most vulnerable members. The very fact of decriminalisation could easily by itself signal to vulnerable groups directly or indirectly, not only that they may seek an earlier death, but that they should. A third response to the argument from autonomy asks how autonomists would requests actually be. Even requests which were not compromised by pressure from grasping or uncaring or exhausted relatives might not be truly autonomous. There is an established link between requests for euthanasia and clinical depression. The Royal College of Psychiatrists has observed that studies of the terminally ill had clearly shown that depression is strongly associated with the desire for a hastened death, including euthanasia, and that once a patient's depression is effectively treated, 98 to 99% change their mind about wanting to die. And a fourth counter-argument is that decriminalising voluntary euthanasia or physician-assisted suicide would not only allow doctors to act on requests that were in practice compromised by pressure or depression, it would also lead in logic to the decriminalisation of non-voluntary euthanasia, the euthanasia of patients who are not capable of making a request. Why is this? Well, this is so because despite the emphasis placed by campaigners on autonomy, the case for euthanasia rests at least as much on the belief that some patients are, because of terminal illness or suffering or whatever, better off dead, that death would benefit them. Campaigners aren't proposing euthanasia should be available simply because the patient has made an autonomous request. According to their own standard proposals, doctors would have to decide whether the patient's request should or should not be granted. And how would the doctor decide? Other than on the basis of a belief that death would benefit the patient. In countries like the Netherlands, which have legalised euthanasia, doctors do not grant all requests, they reject a significant proportion of requests. This illustrates the decisive role played by the doctor's judgment that death would or would not benefit the patient. A doctor who is prepared to make such a judgment that death would benefit the patient forfeits any principal objection to non-voluntary euthanasia. For, if death would benefit the patient, why deprive the patient of that benefit simply because the patient is incapable of asking for it? This logical slippery slope argument is unanswerable, and it can be illustrated by developments in countries like the Netherlands. Just as the Dutch courts in 1984 invoked the doctor's duty to alleviate the patient's suffering to justify voluntary euthanasia, in 1996 they applied precisely the same reasoning to justify lethal injections for disabled babies who are clearly incapable of making a request. The doctor's duty to alleviate their suffering justified lethal injection even for incompetent patients. So as this logical slippery slope shows, permitting voluntary euthanasia or physician-assisted suicide is not a private matter concerning only a few highly autonomous patients. It clearly has profound ramifications for the well-being of all patients who might be judged better off dead, not least those who are unable to refuse it. I'll touch secondly on another important argument in favour of legalisation, the argument from compassion. Don't doctors and nurses have a duty to alleviate suffering? Well, compassion is a laudable emotion. It's not a moral principle. We should feel compassion for the poor, but that would hardly justify robbing banks to redistribute wealth. And some of the most compassionate members of the medical and nursing professions are to be found amongst those who care for the terminally ill, and they are among the strongest opponents of euthanasia. They've long realised that their duty to alleviate their patients' suffering is not a duty to end their suffering at any price. They recognise that true compassion, true suffering with the patient, means caring, not killing, affirming, not denying the patient's worth, promoting solidarity, not suicide. Moreover, if we were to allow euthanasia out of compassion for the terminally ill, how often would our compassion turn out on closer analysis to be counterfeit, a desire not to put them out of their misery, but to put them out of our misery? Secondly, if compassion justifies us in giving a lethal injection to a patient who requests it, why does it not equally justify giving a lethal injection to end the suffering of a patient who cannot request it? Again, the logical slope argument is unanswerable. And euthanasia is by no means the only way to respond to the suffering of the terminally ill, as our wonderful hospice movement in the UK has demonstrated. Palliative care has never been able to help patients as much as it can do today. In 2006, over 70% of members of the Royal College of Physicians and over 95% of those in palliative care agreed with the statement that with improvements in palliative care, good clinical care can be provided within existing legislation and patients can die with dignity. A change in legislation is not needed. So then, what is the take-home message? First, either physician-assisted suicide, voluntary euthanasia, and non-voluntary euthanasia are all ethical, or they're not. In my submission, they're not. Secondly, they're all wrong because they deny the inherent and inalienable dignity that we all share in virtue of our common humanity. A dignity which grounds our right not to be intentionally killed. Thirdly, weakening the law's historic defence of that right would discriminate against the most vulnerable in our community, not least the dying, the disabled, and the disadvantaged. To conclude, I could perhaps recommend some further reading. There is this book I mentioned earlier, Debating Euthanasia. You might also like to look at a couple of other books, one called Euthanasia Examined, Cambridge University Press, 1995, a book I edited containing essays for and against the legalisation of euthanasia. My own book, Euthanasia, Ethics and Public Policy, An Argument Against Legalisation, published in 2002 by Cambridge University Press, the second edition appearing in 2018. Bioethics and the Human Goods, a book I co-authored with my late colleague at Georgetown, Professor Alfonso Gomez-Lobo, published by Georgetown University Press, 2015. And an essay I wrote, which was published in a book published last year, a book called Law, Ethics and Medicine, Essays in Honour of Peter Skegg, published by Thomson Reuters, in which my essay is an extended response to the argument advanced by Professor Jackson in Debating Euthanasia. Thank you.